Dublin, California, February 27, 2011. Sergio Ramirez has come to buy a Nissan Maxima. His wife is with him and his father-in-law. The salesman runs a credit check and says Nissan will not sell him the car. His name is on a terrorist list. The letter that follows will not say how to argue with it. His wife buys the car in her own name. Everything that happens after that, a jury, an appeal, in the Supreme Court of the United States turns on one question. Not whether the list was wrong about him, whether the piece of paper it was written on ever left the building. The dealership ran his credit the way a dealership does. What came back was a report produced by TransUnion, and it carried an alert across the top of it. The alert said that the name that had been entered matched a name on something called the OFAC database. A salesman told him Nissan would not sell him the car because his name was on a terrorist list. That is the entire record of what was said at that counter. Nobody in this film knows what the salesman was looking at or what he had been told because no court ever asked him. He was not a party. He is not named anywhere in either opinion. His wife bought the car in her own name. The next day, Ramirez asked TransUnion for his own credit file. They sent it the same day. It came with the standard federal summary of a consumer's rights, and it did not mention the alert at all. The day after that, a second envelope arrived. This one was about the alert. It told him that the name on his TransUnion credit file was considered a potential match to information on a United States Treasury database, and it did not enclose another copy of his rights. Then the letter explained how this sort of thing is supposed to be checked. Financial institutions, it said, are required to check customers' names against the OFAC database, and if a potential name match is found, to verify whether their potential customer is the person on the database. For that reason, it said, some institutions may ask for your date of birth or ask to see a government-issued form of identification. That is TransUnion's own letter describing the check a bank should make. A date of birth, a piece of identification, something other than a name, and enclosed with it were the OFAC records for the two people he had supposedly matched. The Ninth Circuit describes what those records contain. First, middle and last names. Dates of birth. Passport information. He had two mailings in front of him now. One said nothing about any alert. The other said he was a potential match to a Treasury list. Ramirez testified that he was confused by them. The absence of any OFAC information in the credit report mailing suggested the alert had been removed. The other mailings suggested otherwise. Neither one told him how to dispute anything. He canceled a trip he had planned. The Ninth Circuit calls it an international vacation he had planned with his family. The Supreme Court says he consulted a lawyer and ultimately canceled a planned trip to Mexico. TransUnion eventually removed the alert from his file. So that is one man, over about a week, in one town. A car he did not buy. Two letters that disagreed with each other. A lawyer. A trip he did not take. Everything past that point is about a question he could not have asked at the counter, because nobody at the counter could have answered it. How did a machine decide that his name was on that list? The list is real and it belongs to the Treasury. The Office of Foreign Assets Control publishes a list of individuals and companies owned or controlled by or acting for or on behalf of targeted countries. It also lists individuals, groups, and entities, such as terrorists and narcotics traffickers, designated under programs that are not country-specific. Collectively, they are called specially designated nationals. Their assets are blocked, and United States persons are generally prohibited from dealing with them. The Supreme Court's own summary is shorter. Individuals on the OFAC list are terrorists, drug traffickers, or other serious criminals. It is generally unlawful to transact business with any person on the list. How long is the list? On the 8 Treasury pages retrieved for this film, there is no current count of any kind. There is one official figure from a 2021 sanctions review, which speaks of over 12,000 OFAC designations. But that is a cumulative count of designations, not the size of the list today. We counted the file ourselves. Treasury publishes the list as a data file, and the copy dated the 7th of August 2026 holds 19,199 records. That is our count of their file. It is not a Treasury statement, and we are not going to present it as one. Which brings us to the part of the story that decides it. OFAC does not simply publish names. It publishes, alongside them, the things that tell one human being from another. An entry often will have, for example, a full name, an address, a nationality, a passport, a tax identification or cedula number, a place of birth, a date of birth, former names and aliases. And OFAC tells you what to do with them. Its own procedure, published for anyone who screens names, runs in steps. Step 3. How much of the listed entry's name is matching against the name in your transaction? Is just one of 2 or more names matching? Just the last name? If yes, you do not have a valid match. Step 4. Compare the complete sanctions list entry with all of the information you have on the matching name in your transaction. Are you missing a lot of this information? If yes, go back and get more information, and then compare your complete information against the entry. OFAC knows what happens when you skip that. It has a term for a name so broad or generic that it generates a large volume of false hits when it is run through a computer-based screening system. It calls it a weak alias. Its own search tool carries a warning that using it is not a substitute for undertaking appropriate due diligence. The tool works on approximate string matching. Its scoring runs on Yarrow-Winkler, a string difference algorithm, and Soundex, a phonetic algorithm. It is built, in other words, to return things that are nearly right, so that a person can then check them. And OFAC has a page written for the ordinary person whose credit report has one of these alerts on it. It says the alert is merely a reminder to the person checking your credit that he or she should verify whether you are the individual on one of OFAC's sanctions lists by comparing your information to the OFAC information. If you are not that individual, it says the person checking your credit should disregard the alert. Now, beginning in 2002, TransUnion introduced an add-on product called OFS Name Screen Alert. Here is how it worked in the Supreme Court's words. If the consumer's first and last name match the first and last name of an individual on OFAC's list, then TransUnion would place an alert on the credit report indicating that the consumer's name was a potential match to a name on the OFAC list. TransUnion did not compare any data other than first and last names. The software came from a vendor called Acuity. The Ninth Circuit describes what it did. Acuity's software conducted a name-only search, running a consumer's first and last name against the names on the OFAC list. A search would result in a match if the consumer's first and last name were either identical or similar to a name on the list. The court's own example is that Cortez would match with Cortez. Unsurprisingly, the Supreme Court says the product generated many false positives. Thousands of law-abiding Americans happen to share a first and last name with one of the terrorists, drug traffickers, or serious criminals on OFAC's list. That is not the sentence that decides this case, though. This one is, and it is a footnote. In collecting other types of data for use on consumer reports, such as tax liens or bankruptcy judgments, TransUnion used at least one additional identifier other than the consumer's name: an address, a date of birth, a social security number. OFAC information was the only consumer report data that TransUnion collected using name alone. The company could do it. It did do it everywhere else on the same page of the same report. For a tax lien, a name was not enough. For a terrorist list, it was. There is a second footnote, and it is shorter. TransUnion presented no data showing that any of its name matches through the OFAC product were correct. In other words, and this is the court's own phrasing, TransUnion could not confirm that a single OFAC alert sold to its customers was accurate. When it first began offering the product, the company had determined that the alerts it was placing on consumer credit reports were exempt from the Fair Credit Reporting Act. That was the position. Whether it was right is the next act. In 1970, Congress passed and President Nixon signed the Fair Credit Reporting Act. Among other things, it requires a consumer reporting agency to follow reasonable procedures to assure maximum possible accuracy in the reports it prepares. What reasonable procedures means when the data is an OFAC alert had been said out loud once already. In 2005, a consumer suit. Justice Thomas set out her case in his dissent in this one. TransUnion had sold an OFAC credit report about her to a car dealership. The report flagged her, Sandra Jean Cortez, born in May 1944, as a match for a person on the OFAC list, Sandra Cortez Quintero, born in June 1971. 27 years apart. A jury awarded her $50,000 in actual damages and $750,000 in punitive damages. The district court cut the punitive award to $100,000, and in August 2010, the Third Circuit affirmed that, stressing that TransUnion's failure to, at the very least, compare birth dates when they are available, was reprehensible. The Ninth Circuit, years later, described what that decision had established and what happened next. Plaintiffs presented evidence that, despite being told in 2010 by another circuit court that OFAC alerts were covered by the Fair Credit Reporting Act and subject to the reasonable procedures requirement, TransUnion continued to use name-only searches to produce OFAC matches. Most notably, the Ninth Circuit wrote, the Third Circuit specifically reprimanded TransUnion for failing to use an additional identifier, such as date of birth, to verify the accuracy of OFAC matches. Despite this warning, TransUnion continued to use problematic matching technology and to treat OFAC information as separate from other types of information on consumer reports. In doing so, the court held it ran an unjustifiably high risk of error. That is what a court found on evidence, and it is where this film's account of the company's conduct stops. Between the 1st of January and the 26th of July 2011, the letters kept going out. TransUnion sent the same OFAC letter to 8,184 other consumers who had also requested copies of their credit reports in that window. In July 2011, TransUnion finally stopped sending the letters and began including OFAC alerts directly on the credit reports it sent to consumers. Ramirez sued in February 2012. In 2014, the district court certified a class. In 2016, it held that all of them had standing to be there. Before trial, the two sides agreed on the numbers so that no jury would have to find them. The parties stipulated that the class contained 8,185 members, including Ramirez, and they stipulated that only 1,853 of them, Ramirez among them, had their credit reports disseminated by TransUnion to potential creditors during that same period. Hold on to those two numbers. Everything left in this film is the distance between them. There were 3 claims, and all 3 were about willfulness, because statutory and punitive damages are available under the Act for willful violations and not for negligent ones. 1. A willful failure to follow reasonable procedures to assure accuracy. 2. A willful failure to disclose the whole file because the copies sent to consumers left the alerts out. 3. A willful failure to provide the summary of rights with the second mailing. The trial ran 6 days. Ramirez testified about what happened at the dealership. He did not present evidence about the experiences of other members of the class, and that absence will matter enormously in about 10 minutes. The jury returned a verdict for the plaintiffs, and it awarded the same amount to every one of them: $984.22 in statutory damages, $6,353.08 in punitive damages. Each more than $60 million. TransUnion appealed, and it appealed to a court that mostly agreed with the jury. The Ninth Circuit affirmed the verdict and the judgment. It held that the punitive award was excessive under constitutional due process, and it reduced it from $6,353.08 per class member to $3,936.88. On the willfulness question, it was blunt. The jury's verdict, it said, is consistent with the law and supported by substantial evidence. 3 judges heard that appeal, and they did not agree with each other. Judge Murguia wrote the opinion. Judge McCune concurred in part and dissented in part. She would have held that only the 1,853 had standing on the accuracy claim, and only Ramirez on the other 2. Nobody paid much attention to that at the time. It is almost exactly what the Supreme Court was about to say. To have Article 3 standing to sue in federal court, plaintiffs must demonstrate, among other things, that they suffered a concrete harm. No concrete harm, no standing. That is the first thing the Supreme Court of the United States said about this case on the 25th of June, 2021. Justice Kavanaugh delivered the opinion of the court. He was joined by the Chief Justice and by Justices Alito, Gorsuch, and Barrett. Justice Thomas filed a dissent, joined by Justices Breyer, Sotomayor, and Kagan. Justice Kagan filed a second dissent, joined by Breyer and Sotomayor. 5-4. The holding is one sentence long. Only plaintiffs concretely harmed by a defendant's statutory violation have Article 3, standing to seek damages against that private defendant in federal court. Congress can write a law that says a company owes you something. The company can break it. That on its own does not get you into a federal courtroom. Article 3 standing requires a concrete injury even in the context of a statutory violation. An injury in law is not an injury in fact. So where is the line? The court drew it in a place that has nothing to do with whether the alert was true. The standing inquiry in this case, the court wrote, distinguishes between credit files that consumer reporting agencies maintain internally and the consumer credit reports that consumer reporting agencies disseminate to third-party creditors. The mere presence of an inaccuracy in an internal credit file, if it is not disclosed to a third party, causes no concrete harm. And then the court chose an image for it. The plaintiff's harm, it said, is roughly the same, legally speaking, as if someone wrote a defamatory letter and then stored it in her desk drawer. A letter that is not sent does not harm anyone, no matter how insulting the letter is. So too here. What about the risk that it would be sent later? The court held that the risk of dissemination to third parties, was too speculative to support Article 3 standing in a suit for damages. So the 8,185 split in two, 1,853 class members whose credit reports were provided to third-party businesses suffered a concrete harm and had standing on the accuracy claim. 6,332 class members whose credit reports were not provided to third-party businesses did not suffer a concrete harm and did not have standing on it. As for the two claims about the format of the mailings, the incomplete file and the missing summary of rights, none of the 885 other than Ramirez himself had suffered a concrete harm at all. The judgment below was reversed and the case was remanded for further proceedings. Not dismissed, not decided against the class on the merits. Sent back. On remand, the court said, the Ninth Circuit may consider in the first instance whether class certification is appropriate in light of our conclusion about standing. Now, it would be very easy to make the majority sound stupid here, and it was not. Here is the strongest thing in the opinion, and it is aimed straight at the 6,332. The plaintiffs did not present any evidence that those class members even knew that there were OFAC alerts in their internal TransUnion credit files. If those plaintiffs prevailed in this case, the court wrote, many of them would first learn that they were injured when they received a check compensating them for their supposed injury. That is a real problem, and a court is entitled to notice it. A person who never learned of an entry that never moved is going to have a hard time saying what it did to them. 4 justices had an answer. Justice Thomas wrote first for himself and 3 colleagues, and he began with the facts rather than the doctrine. TransUnion, he wrote, generated credit reports that erroneously flagged many law-abiding people as potential terrorists and drug traffickers. Yet despite Congress's judgment that such misdeeds deserve redress, he went on, the majority decides that TransUnion's actions are so insignificant that the Constitution prohibits consumers from vindicating their rights in federal court. The Constitution does no such thing. On the machine itself, he was brief. The system TransUnion used to decide which individuals to flag, he wrote, was rather rudimentary. It compared only the consumer's first and last name with the names on the OFAC list. It did not compare birth dates, middle initials, social security numbers, or any other available identifier routinely used to collect and verify credit report data. And he answered the majority's best argument with one line from the trial record. Quoting the Ninth Circuit's footnote, he wrote that TransUnion could not confirm that a single OFAC alert sold to its customers was accurate. Think about what that does to the desk drawer letter. The question was whether an alert sitting in a file unsent had harmed anybody. The company that wrote it could not show that even one of the ones it had sent was correct. One need only tap into common sense, Justice Thomas wrote, to know that receiving a letter identifying you as a potential drug trafficker or terrorist is harmful. All the more so when the information comes in the context of a credit report, the entire purpose of which is to demonstrate that a person can be trusted. He also thought the decision might not do what TransUnion wanted. State courts are not bound by the limitations of a case or controversy or other federal rules of justiciability, even when they address issues of federal law. If federal courts are closed to these plaintiffs, state courts are not, and a defendant cannot remove a case to a forum that has no jurisdiction over it. He called that a possible Pyrrhic victory for TransUnion. Justice Kagan wrote separately and shorter. The court here, she wrote, transformed standing law from a doctrine of judicial modesty into a tool of judicial aggrandizement. It holds for the first time that a specific class of plaintiffs whom Congress allowed to bring a lawsuit cannot do so under Article 3. To say, as the majority does, that the resulting injuries did not exist in the real world, she wrote, is to inhabit a world I don't know. Congress, she said, is better suited than courts to determine when something causes a harm or a risk of harm in the real world. And then she asked the question this film has been walking toward for 27 minutes. But why is it so speculative that a company in the business of selling credit reports to third parties will in fact sell a credit report to a third party? She noted, as Justice Thomas had, that nearly 25% of the class already had these reports sent to potential creditors. Now, what did the Supreme Court actually decide? Less than almost anyone remembers. It did not decide whether TransUnion violated the Fair Credit Reporting Act. The one innovated 53 keep that claim, and Ramirez keeps all three of his. It did not decide whether the violations were willful. The word appears exactly once in the majority opinion, inside a quotation of the statute and never in its analysis. The jury's finding on willfulness and the Ninth Circuit's affirmance of it were simply not before the court. It did not decide whether the class was properly certified. It sent that question back. It did not decide whether the 6,132 could sue in a state court. Justice Thomas raised it. The majority did not answer it. It did not decide what would have happened in a suit for an injunction rather than damages. The court's own reasoning reserves that a material risk of future harm can satisfy concreteness in the context of a claim for injunctive relief to prevent the harm from occurring. This was a claim for money, and it set no figure. It did not remit, recalculate, or apportion anything. The Supreme Court removed people from claims and sent the case back. The only per-person numbers anyone ever wrote down are the jury's $984.22, its $6,353.08, and the Ninth Circuit's reduced $3,936.88, all of them as awarded or as ordered reduced. None of them as received. One more thing about what the case is not. It is about one add-on product at one company. It is not about credit scores, and it is not about Equifax or Experian, neither of which is mentioned anywhere in it. Two words, a first name and a last name. That was the whole comparison. The record this film is built on ends on the 25th of June 2021, with the case on its way back to the Ninth Circuit. What happened after that, whether the 1,133 ever recovered anything, whether the class was certified again, whether it's settled, is not in any document we were able to retrieve. So this film ends where the record ends. 8,185 people were told by a credit bureau that their names matched a Treasury list of terrorists and drug traffickers. 1,853 of them had that sent to somebody else. 6,332 of them were told by the Supreme Court of the United States that nothing had happened to them yet. Most of them, the majority pointed out, did not know. Justice Kagan's question is still on the table, and it is a short one. Why is it so speculative that a company in the business of selling credit reports will in fact sell one?